Hi everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. This is my Facebook page, guys. If you want to join us, we're a private group and we talk about all kinds of foreclosure related matters. We have files that we share with each other and motions that we share with each other, so we help each other out. And so if you are in foreclosure or you know someone that is in foreclosure, come and join us. We'll make sure that you're helped as much as possible. Okay, today we're going to talk about Aleta Chapman's case. It's taking a turn. Let's look at the case that is currently in the eviction court in Fort Bend, Texas. Fort Bend County, Texas. As you can see, they filed their eviction on August the 22nd, 2024. She filed a motion to dismiss for lack of subject matter jurisdiction. She also filed an emergency TRO, a sworn statement, whatever, judicial notice, and they ignored every single one of them. They wanted her to be at a bench trial. The first bench trial was scheduled on 9/9/24. Excuse me, is that right? Yeah. Well, anyway, it was rescheduled to the 17th, as you can see, and that's today. She did file her notice of removal on 9/9, though, as you can see right there. And on 9/10/24, the very next day, was when she had her bench trial, which was rescheduled for today, when it should have just been disposed of. Because whenever you remove a case from one court to another, then the case that it came from is no longer there. It should be disposed, and they're not disposing it. And she did not show up for her bench trial this morning, and she knows that by not going, she's not going to give them the opportunity to evict her. They do have to follow the same rules of civil procedure as everybody else. The fact that she's pro se, and they are discriminating against her because she filed her notice of removal timely within 30 days, which it was. Let's take a look at what it looks like in the federal court. Let's see. This is the federal court jurisdiction, where it is. And you can see the case number right there. 424 CV 03344. And as you can see at the top here, the case number, and look, related case. That's her quiet title action, which was removed to federal court. Okay, and then you can see the case in other court is the Justice of the Peace Court, and there it is. There's a case number. So they know about her case in federal court. They know about her eviction case. And as you can see on 9/9/24, here's her notice of removal. So it made it. She also paid the filing fee, which is like $405. So she did this on 9/9. And the case is now technically in the federal court. But if you look at the state court, even though it was removed, they're not letting it go. It's like they don't like pro se litigants. They like to discriminate against us. But they can't do that lawfully. Anyway, let's talk about the next thing that's going to happen here. What she's going to end up doing is filing a motion to dismiss in the federal jurisdiction. So this is what the heading looks like. In this case, she's the defendant, not the plaintiff, because she removed it to federal court. And only the defendant can remove a case to federal court within 30 days of it being filed. And she did. So let's see what her actual case is looking like. Motion to dismiss, statement of facts, argument, efficiency and judicial economy, conclusion, table of authorities. That's what we got so far anyway. Alright, this is her memorandum of law. Defendant Aleta Chapman respectfully moves this court to dismiss the complaint filed by plaintiff U.S. Bank Trust National Association, not in its individual capacity, but solely as owner-trustee for the RCF2 Acquisition Trust on the grounds that the present action is duplicative of an existing case pending before this court. The case number 424 CV 03260. This motion is filed in accordance with Local Rule 5.2, which requires the disclosure of related litigation. Statement of facts. On June 17, 2024, plaintiff filed a lawsuit regarding title dispute against Saline Financial in the 400th Judicial District Court, Fort Bend County, under state case number 24-DCV-317315. This was state court. She filed her quiet title action. On September 4, 2024, defendant Saline removed it to federal court in the district, and a new case number was assigned, and that's that case number. On August 22, 2024, U.S. Bank Trust National Association, not in its individual capacity but solely as owner-trustee for RCF2 Acquisition Trust, filed an action in state eviction court in Fort Bend County under case number 24JEV01058. And we just looked at that. On September 4th, 2024, Aleta Chapman filed her first amended complaint adding U.S. Bank Trust N.A., the plaintiff in this case, to her federal case. On September 4th, 2024, Aleta Chapman removed the state eviction case to federal court. This case, the current case, actually it should be September the 9th. Anyway, the current action case number blah 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 involves the same parties, issues, and legal claims as the existing case. Pursuant to LR 52, the parties are required to notify the court of related litigation. Therefore, this motion also serves to inform the court of the substantial overlap between the present case and the related case already pending before this court. Argument. Aleta Chapman argues that the first filing rule should be applied. First filing disputes generally arise under one of two circumstances. Under the first scenario, a plaintiff simply files a case against the same or similar parties in more than one court. See Sims Motor, Inc. versus Ford Motor case law. And then here's a footnote that states, under the first file rule, when two courts have jurisdiction over the same case, the court in which the case was first filed should be the court to hear it, except under special circumstances, because the first filed rule intends to prevent duplicate litigation. It applies only where the actions before both courts involve the same or substantially similar parties and issues. By ensuring the parties to a single controversy handle their dispute in one forum, the rule prevents two courts or equal rank from issuing conflicting rulings and promotes judicial conformity. Further, the first filed rule prevents the wasteful preclusion consequences that may arise from courts exercising concurrent jurisdiction. Preclusion is a term used to group a variety of doctrines which are intended to prevent parties from relitigating claims or issues which a court has already adjudicated. Under the second scenario, a plaintiff files a case in one court, and then, instead of filing counterclaims in the original suit, the defendant chooses to file those claims as a new suit in another court. And then there's case law for that. Because the original plaintiff, Aleta Chapman, filed her suit first, the original plaintiff's suit would have priority under the first filed rule. Efficiency and judicial economy. Allowing both cases to proceed would waste judicial resources and potentially lead to inconsistent rulings. Conclusion. Wherefore, based on the foregoing, the defendant, Aleta Chapman, prays that this court will dismiss this case because it's of its duplicative nature. And then there's, of course, a certificate of service to the law firm for the other side. So you guys see what's going on here a little more clearly in layman terms. Aleta Chapman is fighting her foreclosure in such a way that she's not going to let them get away with what they're trying to pull. And if you guys have any comments or questions, you can send me an email to foreclosurehelp777@gmail.com, or you can leave some comments and I will answer your comments. And I hope everyone has a wonderful day, and God bless.